appeal in the matter of Millett and the Right Honourable Jeremy Corbyn MP.
Yes, Mr Hudson.
May it please the Court. In this appeal, I appear for the defendant appellant, Jeremy Corbyn. I appear with my own junior, Mr Henderson. The claimant respondent, Mr Millett, is represented by William Bennett of Queen's Counsel and Mr Stables.
Yes.
This appeal, as the Court will appreciate and know, is with the permission of Lady Justice Andrew, granted on the 30th of October, and the permission decision is in the core bundle at tab 4, page 17, and it is against paragraphs 3 and 4 of the order of Mr Justice Saini of the 13th of July, following the trial of preliminary issues in this libel action.
Yes.
And as the Court is aware, Mr Justice Saini decided and ordered that the meaning in the statement complained of was a statement of fact, not opinion, and that the meaning was defamatory.
Mr Hudson, have you agreed a timetable with Mr Bennett?
My Lord, we've had a brief discussion, and we're listed, as I understand, for a day and a half. I think that probably gives me about till 3 o'clock today, subject to my Lord, my Lady. We propose to review that at lunchtime, depending on how much progress I make and how much time my own friend Mr Bennett thinks he will need. But I anticipate I have to finish around 3.
Right. Okay. Well, that's fine. I mean, the issues are fairly narrow.
Well, Lord, yes, they are narrow. There are some areas that the Court may wish or may not wish to go into, which are slightly more expansive, but I'll obviously be entirely guided by my Lords and my Lady.
Well, you take your own course, Mr Hudson.
I'm grateful. My Lord, can I just check the Court has the documents that we think the Court should have? There is an electronic hearing bundle, both core and supplementary.
Yes.
There's the video clip of the programme, which is 24 minutes long, which I hope the Court or members of the Court have had an opportunity to view the whole clip.
Yes.
I'm grateful. There's a bundle of authorities, which is no doubt more extensive than it needs to be.
There's now a tailored bundle of authorities.
It is,
Yes.
but probably not even tailored enough, but we'll see. My Lord, there are skeleton arguments from both sides, including a supplementary skeleton argument from the respondent, and there's a recent corrected skeleton argument from us, but it just simply added some references and corrected some typos, but nothing more.
Yes. We've got all that, but you should be aware that I only use electronic documentation, so please may I have electronic page numbers?
My Lord, yes,
Thank you.
I will endeavour to do that.
I think we're all only using electronic documentation, so no paper.
Excellent. My Lords, my Lady, I propose to deal with the following 5 main matters, if I may, and they are as follows. Firstly, I want to make some, if I may, some brief observations about the claim, about Mr Millett's claim and the programme.
Yeah.
Secondly, some very brief observations about the test, the appropriate test on appeal. Thirdly, comment briefly on the issue of meaning in this case.
Meaning is not appealed.
It's not appealed, but I just want to say something briefly about that, if I may.
Yes.
I won't deal with that now. I'll take it in sequence if that's acceptable, or I can make the point I want to make now if that suits the Court.
No. Take it in your own course.
But I accept it is not. We were refused permission to appeal on that, and therefore the meaning as found by Mr Justice Saini is the meaning.
Yes.
I accept that. Fourthly, we then come to the meat, if I may say so, of the appeal, which is the first ground in the skeleton, albeit second ground in the grounds of appeal, namely whether it is opinion or fact, and whether the learned judge erred, whether it law or fact in deciding it was fact. And then fifthly, defamatory meaning, whether the meaning was defamatory at common law. Those are the 5 main topics I propose to address. But at the outset, if I may, I would like to say something about the importance of this appeal from the perspective of Mr Corbyn. My lords, my lady, we wish to make the point that in our view, in Mr Corbyn's view, this appeal raises important issues in relation to the law of libel in the context of political speech, dealing as it does with sensitive and controversial matters, and concerning as it does the statements of a very senior politician, which we contend are statements of opinion or expressions of opinion, and whether those are defamatory common law. And as I know the court knows only too well, as has been observed in various cases, including by the European Court of Human Rights in the case of Jerusalem, that cases involving politicians and political speech require the closest scrutiny by the court. And we submit that it is important, we say, to bear in mind that the claim being brought by Mr Millett and the decision of Mr Justice Saini against which we appeal amounts, we submit, to having a serious chilling effect on political speech. And in summary, we say that applying 21st century standards to speech and expression, particularly political expression, that the warning given by Lord Atkin in the case of Sim and Stretch, which was referred to by Mr Justice Tugendhat in the case of Thornton, applies particularly well to this case, namely that the protection for injuries to reputation is, quote, undermined when exhibitions of bad manners or discourtesy are placed on the same level as attacks on character and are treated as actionable wrongs. And my lords, my lady, we say that is what is happening in this case as a result of the decision of Mr Justice Saini. My lords, my lady, with those brief observations, could I then turn to my 5 main topics? The first one being the claim and the programme. As the court is aware, this is a claim for libel. It arises out of statements made by Mr Corbyn when he was the leader of the opposition and was interviewed on the political programme, the Andrew Marr programme, on the 23rd of September 2018. And we note that that is now 2.5 years ago. The claim form, which is at tab 9 of the core bundle, and no doubt the court will have seen that, was issued in June of 19, nearly 9 months after the broadcast. And that is a claim for £100,000 and a permanent injunction against Mr Corbyn. And that permanent injunction is sought despite the fact that the programme remains on the BBC iPlayer website, and no relief is being sought against the BBC to stop that programme and Mr Corbyn's statements from being broadcast by the BBC. And we submit that such a sizable claim, a claim for £100,000 in libel, has been hanging over Mr Corbyn now for over 2 years, and we are still only at the beginning of this litigation, a defence not even having been filed yet. And it is important also, we say, to remember that although Mr Justice Saini decided that Mr Corbyn's comments referred to Mr Millett, Mr Corbyn did not name Mr Millett. And we say that is, again, an important consideration when deciding, for example, the question of defamatory tendency of common law. The parties, the nature and role of the parties is summarised in the particulars of claim, paragraphs 1 and 2. I don't propose to say anything further about that. The court will have seen those. The court will have seen the programme, I hope, in its entirety, and we do submit it is necessary to watch the full 24 minutes, because that is most likely what a reasonable viewer would have done. They would have watched the whole 24-minute segment of the programme involving the interview with Mr Corbyn.
I think we have to assume that happened, don't we? We have to assume that the reasonable viewer did watch it.
My lord, with respect, I agree, yes. And the reasonable viewer would have only have, again, one has to assume, would only have watched the programme once. I think that's a particularly safe assumption when it concerns a broadcast rather than an article or a newspaper. And we suggest viewers would appreciate that this was a serious political programme, and this segment of it was a particularly hard-hitting, challenging interview of Mr Corbyn. It was made very clear at the outset of the programme that it was the main event, that the interview with Mr Corbyn was the main event. That phrase is not caught on the transcript, but it's clear from the beginning of the programme that Mr Marr says, and so to the main event, which is the interview with Mr Corbyn. The whole interview was highly political. There was very much discussion about Mr Corbyn's views and opinions on a whole variety of issues, from Brexit and the EU, and then allegations of anti-Semitism which had been levelled against Mr Corbyn. And it is clear, we say, that throughout, Mr Corbyn was being asked to express his views, his opinions, his judgment, his criticism, etc., on all of the topics that Mr Marr was raising with him. It's also important, we say, to appreciate that at that point in time, September 18, as is made clear by Mr Marr, a general election could have taken place within a few months. And as Mr Marr observes to viewers, Mr Corbyn was hoping to be the next Prime Minister in a very short few months. So, very senior politician. And then at just under 8 minutes into the programme, Mr Marr asks a direct question from nowhere whether Mr Corbyn was an anti-Semite. Then there was a discussion, a debate, observations, expressions of opinion by Mr Corbyn about that, during which he denied absolutely that he was. And Mr Marr said to Mr Corbyn that this was Mr Corbyn's opportunity to explain the things that had happened, and explain to people what had happened and why they had happened. And then Mr Marr played the footage from the speech of 2013, it's around 10 minutes 23, and the transcript of that is in Supplementary Bundle, tab 1, page 9. And if I may, I'd make the following observations about what viewers see when they look at that bit of footage. They can see clearly that Mr Corbyn is speaking at an event, which was recorded in 2013. It can be seen clearly in the background that the event was either organised by or related to or concerned the Palestinian Return Centre. Mr Corbyn refers to Manuel, who he identifies as the Palestinian ambassador, and expresses his opinion about the speech that Manuel Hassassian had made, describing it as incredibly powerful, passionate and effective, and importantly, that the speech was about the history of Palestine and the rights of the Palestinian people. Mr Corbyn then commented on the Zionists in the audience, saying that they were silent on that occasion, but came up and berated Mr Hassassian afterwards for what he had said. Again, obvious to viewers that that was a description by Mr Corbyn of what he saw happen at that event. The reason I make these points is because we submit it is obvious that viewers would appreciate that these were highly sensitive, controversial political issues which provoke profound disagreement amongst right-thinking people, if I may be permitted to use that old-fashioned phrase. But they do. There's no right or wrong answer on these topics. It would not surprise viewers that at such an event there had been an exchange of views, a heated exchange of views between the speaker, the Palestinian ambassador, and those so-called Zionists, which Mr Corbyn had described as attending the meeting. That would be of no surprise to anyone at all. And importantly, and this is a point we submit that wasn't fully taken into account by Mr Justice Saini, at the conclusion of the clip that's played of the 2013 speech, Mr Marr turns to Mr Corbyn and says, "Strange thing to say." That is in reference to the 2013 speech. And we submit that that phrase, "strange thing to say," is a clear invitation and would be understood by viewers as a clear invitation by Mr Marr to Mr Corbyn for him to express his views, his opinion about the 2013 speech and what he said, to explain it from his perspective. And that, my lords, my lady, is precisely what Mr Corbyn then did in the passages that are complained of. The particulars of claim appears to actually complain about the 2013 speech as well, although there seems to us there are problems with that, but we don't need to get into that for present purposes. The statement that I've complained of is precisely that bit where Mr Corbyn has been asked to explain. Well, also, my lady, I'm grateful for allowing me to deal with that in some detail, and if I may then turn to my next four headings. The second one, heading number 2, being the test on appeal. And I only raised this because there's been some debate in the skeleton argument, particularly in the supplementary skeleton argument, about what is the appropriate test on appeal. And I can put it simply, if I may, in this way, that we suggest it is not necessary to get into the issue, what are issues of fact and what are issues of law in defamation cases, and whether a jury in the old days and a judge now finding the meaning as an issue of fact or law doesn't really matter, although on reflection I accept that if I have to, I accept that is a question of fact, and I know my lady, the President, has decided, amongst others, that it is a question of fact, and that's entirely understandable. But it doesn't matter, we say, for this reason, because as the Supreme Court have observed in Stocker and Stocker, even where the issue is one of fact, if it is vitiated by an error of law, then it is wrong for the purposes of this court's powers on appeal, and the appropriate course usually is for this court to consider the matter afresh. Obviously, we're not dealing with the challenge to meaning, we're dealing with the challenge to a decision on fact versus opinion and defamatory meaning. If I have to, I'm willing to argue that those two questions are actually either issues of law or issues of mixed fact and law, but again, I submit I don't really need to, subject to the views of this court, obviously, because we say they are all errors of law.
Mr Hudson, I mean, you know, I look at these things fairly straightforwardly. You've got to show us the judge was wrong.
Yes.
And as I always put it, you've got to get your screwdriver into his judgment.
Yes.
To show us that he was wrong.
Yes.
And if he's plainly wrong, then may be an analysis of exactly whether it was precisely a question of law or clearly a mistake of fact. If he's plainly wrong, he's plainly wrong.
My Lord, yes.
Yes. And that's where you need to go.
Well, my Lord, I'm grateful on that. May I then open my toolbox?
Yes,
and start with my grounds. Before I do that, I was going to say something about meaning, and that was my third heading, and it's simply to say this. We would obviously love to challenge the meaning found by Mr Justice Saini, but we can't. We're stuck with that. But I want to make this point, and it relates to the question of whether or not it is opinion or fact. And I make this point. If this court considers the matter afresh, whether or not it is opinion or fact, which we will invite the court to do, if the court accepts the decision of Mr Justice Saini was plainly wrong, then we will submit that the correct question for the court is not in fact the question whether the meaning found by Mr Justice Saini was a statement of opinion or fact. The correct question is whether the statement complained of is a statement of opinion or fact.
I thought that you were at one with Mr Bennett now on that point, in view of his further scouting argument, but we'll see.
Oh yes, our position is, so I'm clear, our position is that although the order of Master Cook directed on the trial of a preliminary issue, and I can take my lord and my lady to that now or later if when appropriate, that one of the issues to be determined was whether the meaning that Mr Justice Saini found, or whichever judge decided the trial of a preliminary issue, was a statement of fact or opinion. That was the wrong question, or at least ought to have been expressed differently in accordance with Section 3 of the Act, and also in accordance with the current practice direction, although the current practice direction didn't apply to this claim because of the timing. But either way, whether this court looks at the statement complained of or the meaning as found by Mr Justice Saini, we say it is clear that on either basis it is a statement of opinion, not a statement of fact. But I can come back to that if
it would probably be prudent to address both, because you don't know what the court is going to decide.
My lady, of course. I'm grateful for that.
I see that the judge said in paragraph 85, you argued that the allegations were opinion by reference to your own meaning.
Yes.
Is he right about that?
My lord, he was, yes. We and with hindsight, I adopted the wrong approach with hindsight, and what I did, we don't criticise the judge at all for this, and I only raise it because this court may have to reconsider the issue. But we approached it on the basis of the order that Master Cook had made. And again, I don't criticise Master Cook because that was an order drafted by the parties.
Yes.
I haven't quite been able to get to the bottom of how it came to be in that form, but it doesn't really matter. That's where we ended up, and that's why we argued. And that is the way in which we argued it. But if this court, we would suggest, both looking ahead, and if this court considers the matter afresh, the appropriate question on Section 3.2 of the 2013 Act is whether the statement complained of was a statement of opinion or fact. Although, again, I have to emphasise, we will argue it actually makes no difference to the outcome which approach one adopts.
Can you help me with something,
My Lord, yes.
Mr Hudson?
Right,
See, I'm the new boy in this court to defamation. I've been looking at both the meaning the judge found
Yes.
and the statement complained of and so on. And plainly there is an issue between fact and opinion, which is not entirely straightforward for the newcomer.
Yes.
Perhaps I'm the reasonable person just watching the interview and thinking about what it was. And what I've wondered about is if there is I mean, in nearly every statement, there may be some opinion and some fact.
My lord, yes.
And what I wondered is what you have to show. So do you have to show that it's all opinion?
No.
Or do you have to show that it's a little bit? Well, is it enough for you if it's a tiny bit opinion and lots of fact? Or where does the balance lie?
Well, my lord, it is a difficult question. It seems to us, looking at the Act, which ought to have been the way this was approached. And again, I'm not criticising the learned judge. If it was anyone's fault, it was our fault. Looking at the Act, the question under the Act, under Section 3.2, is was, and it is past tense, was the statement complained of a statement of opinion or a statement of fact? Sorry, was it a statement of opinion? My lords,
what page is it?
It's page Joint Authorities Bundle, tab 22, page 454.
This is the sidelined authorities bundle, the new one.
It should be, my lord, yes. I hope.
Did you say 22?
Tab 22, page 454.
Yeah.
So section 3, honest opinion.
Yeah. Statement complained of was a statement of opinion.
Was a statement of opinion, my lord.
Yes.
To the extent that matters.
No, probably does. Yes.
The statement complained was a statement of opinion. So, my lord, it seems to us that on the trial of a preliminary issue, and one mustn't forget that's what this was. The issues that a court can sensibly determine as preliminary issues on the question of honest opinion are the issue or the first condition for the defence of honest opinion, namely, was the statement complained of a statement of opinion, which was what was intended to be ordered in this case. And arguably the second condition can be ordered as a trial for a preliminary issue trial as well, although it wasn't in this case, and that's one of our sub-grounds of appeal.
Yes.
That's what the judge actually ended up doing when he shouldn't have done. So to try and answer my lord's questions, it seems to us that what has to happen in that situation, the judge has to look at the statement of complained of and decide whether or not it is in whole or in part a statement of opinion. And so, to answer specifically my lord's questions, it's simply a question of identifying whether any of the statement complained of constitutes a statement of opinion. So, if the judge decides there are in this statement complained of, there are statements of opinion, and they are the following 1, 2, 3 statements. And I'm deliberately not saying imputations, but they are statements. So I want to use an example from this case, but that's probably not helpful. But the court will easily think of examples of expressions of opinion. And that's what.
Well, I mean, can I give you an example?
Yes.
This is just almost off the cuff. If you say he shouted at me,
yes,
that is a fact, I think.
Probably.
Normally.
Normally.
I mean, sometimes one thinks people are shouting when they're not, but just taken at face value to the reasonable person, he shouted at me is a question of fact.
Yes.
And if you say he is stupid, that is probably a question of opinion.
Yes.
Those words would be broadly clear.
Yes.
The words we've got here are intermediate words, potentially. That's why I'm asking the question.
Yes.
potentially they're intermediate words. They
Yes.
could mean one thing in one context and they could mean another.
Yes.
I mean, you know, I don't want to take examples from the case either because it's probably not helpful. But it's easy to imagine abuse. I mean, I will nonetheless.
Yes.
Abuse is something that is, if you take physical abuse, probably a fact.
Precisely.
But that's not what Mr. Corbyn was talking about here. And disruption, well, you know, I don't know. I mean, you're going to tell me, but what I'm asking is, because it seems strange to me, if it's mostly fact and only a weeny teeny bit opinion, does that come within this defence?
My Lord, it does. And we submit, actually, it's quite straightforward. One looks at the statement.
Yes.
Let's say there's one paragraph. It's a one-paragraph statement, let's say. Within that statement, there are 10 sentences. Only one of those sentences is, in truth, a statement of opinion. There's no argument. It's clearly a statement of opinion, but the rest are clearly statements of fact.
You give lots of facts, and then you say at the end, and he's stupid.
Yes. And let's say there's no debate that the first 9 are clearly statements of fact, but the last statement is clearly a statement of opinion. Section 3.2 is then satisfied, but only in relation to that 10th sentence.
Right.
But that's all one needs to know and decide for Section 3.2, because all the court is deciding under Section 3.2 is the first condition of the defence met? And so the judge will say the first condition, or the sentence number 10 was a statement of opinion. The parties then know that sentence number 10 meets the first condition of the honest opinion defence, but sentences 1 to 9 don't.
Well, that bit I get, Mr. Hudson, very quickly. But the thing I don't get is if the single sentence, he is stupid, could be regarded as fact or could be regarded as opinion, or is mixed fact or opinion, then is Section 3 satisfied?
Well, then the court has to make the binary decision.
Yes.
Is it fact or opinion? And we'll get into, as my Lord is aware, the case, the guidance and the principles which govern whether a statement is one of fact or opinion, whether it's opinion, because even though it's a statement of fact, it's an inference of fact.
Everybody seems to agree with my lady's formulation in but. It's just that it's a rather, it's got a lot of words in it to describe it. So
But my Lord, that point is, if I may say so, simply a question of the court making a decision, a binary decision. Is sentence number 10 a statement or fact or opinion? Sometimes it will not be easy.
Right, but the court has to decide.
The court can't say, well, it might be or it might not be. The court has to determine whether at the trial of a preliminary issue or at the full trial.
And am I right in this? I'm sorry to ask all these questions, but it helps me. The context, obviously context is critical.
Yes.
The only relevant context is the material itself.
My Lord, yes.
In this case, the interview itself.
Yes.
But the whole of the interview.
Yes. We say the full 24 minutes.
Yes.
And all of some of the points that I've already made.
Because even this question is to be looked at, and you'll correct me if I'm wrong, Mr. Hudson, through the eyes of the reasonable viewer, and only through the eyes of the reasonable viewer.
My Lord, yes. My Lord, that's right. And we do adopt, with the greatest respect, my Lady the President's analysis of this in Bart.
Yes.
And I will take the court to that, if the court can bear it. I will take the court to that.
Well, I've certainly looked at it carefully.
But that is the question.
I would like to see it again, yes.
That is the question. And the court simply has to answer that binary question. And if the court answers it yes in relation to sentence number 10, then the first condition of the honest opinion defence is met in relation
for sentence 10.
For sentence 10.
Yes.
And then the parties then know that the defendant has overcome the first hurdle of the honest opinion defence, which we say that actually should be the easiest hurdle, because the others are actually quite hard, potentially.
Yes.
But sentences 1 to 9, the defendant can't rely on the defence of honest opinion. The defendant then has to look elsewhere, whether it's truth or public interest or whatever.
Well, only if they're defamatory.
My lady, of course, yes. Yes.
Yes.
Why should the first condition be the easiest?
My Lord, because, as my Lord has observed, my Lady the President has observed on many occasions, honest opinion is a defence which is absolutely fundamental to freedom of expression. And my Lord has observed that free rein should be given to comment, to honest opinion. And we suggest the way to do that is to be generous, although I don't say that needs to happen in this case, but the court, we submit, should be generous in deciding whether or not a statement is a statement of fact or opinion, so that at least the defendant meets that first threshold. Because, as I say, the other thresholds are quite tough, or potentially quite tough. And as we say in our skeleton argument, just because the statement complained of is characterised as opinion rather than fact does not give a defendant carte blanche to make defamatory, to express defamatory opinions about someone. And it is... Sorry, my lady.
No, I was going to say my experience is that it's the opinion fact question which normally proves knotty rather than what happens after that.
My lady, with respect, I'm sure that's right, that it's a difficult question, but it is because our submission is because it is the gateway to this incredibly important defence. It should be one that the court is very slow, as my Lord Justice Warby has said on a number of occasions, and I'm paraphrasing, the court should be very slow to determine that a statement is one of fact rather than opinion. If there's any doubt, and particularly if, as in this case, we're dealing with speech at the farthest end of the spectrum in terms of deserving of protection under Article 10. And it may be once a defendant overcomes that first threshold, then often they will be able to succeed in the defence of honest opinion. But the other conditions of the defence, we submit, do provide proper and well thought through protection for the Article 8 rights of a claimant of protecting their reputation. So, as the court knows, the second condition is the one which we say is the bare comment protection, or the protection against bare comment. The third is that it could have been held by an honest person. And then, importantly, the defence is defeated if it's proved or shown that the claimant didn't in fact hold that opinion. So we say those are not insubstantial protections for a claimant's Article 8 rights, and has clearly been thought through very carefully by Parliament in the light of the decision of the Supreme Court in Joseph and Spiller. My Lord, I realise I got distracted from the point I was trying to make. I was making on meaning.
My fault.
Well, it's probably because it was a rubbish point. But as I say, the only reason I mention meaning is if the court considers this afresh, I accept I'm stuck with the meaning of Mr Justice Saini. Although, I'm stuck with it. I won't say any more than that. But we say that it is not that meaning which this court looks at if the court considers the matter afresh. And I will take the indication from my
Mr Justice Saini did consider the matter by reference to his meaning rather than the statement complained of.
Having several times looked at Mr Justice Saini's judgment, it looks as though that's what he did. But equally, it looks as though he was looking at the statement complained of. But also, as my lord is aware, one of our complaints is that he appears to have taken into account matters that weren't in his meaning, particularly the issue well, this is on defamatory tendency, criminal misconduct.
Well, he starts his consideration of this issue by referring to what Mr Justice Nickton said in QC Canons as to the principles in determining whether the words complained of should be regarded as factual opinions. So, and then he records, apparently accurately, that you both argued it on the basis that the meaning is what mattered.
Which we did, yes.
And his conclusion appears to me was to be consistent with his starting point.
Yes.
It's not.
Yeah. Well, with respect, we agree. It was unclear. It's unclear to us, and no criticism, Mr Justice Saini. I have no doubt I could have been clearer, and I ought to have dealt with that issue differently in front of Mr Justice Saini. But we were, not that this is an excuse, but we were going by the order of Master Cook. But if this court comes to consider the matter afresh, we say it is well within this court's powers to determine the section. Mr Justice Saini was determining the section 3.2 issue. That's what he was doing.
We have to do it expressly and properly
Lord,
if we do it again.
My lord, exactly.
If you've got your screwdriver successfully in.
My lord, yes.
Yeah.
Right. Well, I will finally try and get my try and deal with that. Yes. So, opinion or fact is my fourth heading.
Yes.
So, as my Lord Justice Warby has pointed out, the decision of Mr Justice Saini is paragraph 88, which is tab 8, page 81 of the core bundle. Now, the learned judge doesn't appear to give any reasons for his decision that Mr Corbyn was making factual allegations. So the judge sets out the arguments and sets out our arguments in some detail, but doesn't give any reasons other than their comment as to why it was a factual allegation. And we contend, as the court is aware, that the judge erred in three significant respects in reaching that conclusion. And we've set them out in the skeleton, summarised at paragraph 12a of the skeleton, and they are our grounds 2a to c in the grounds of appeal, albeit the court will have noticed for some reason we've dealt with the grounds of reversal in the skeleton, and I propose to follow the pattern of the skeleton in my submissions, if I may. So the three significant errors are as follows, and we say each of these on their own is sufficient for this court to conclude that the judge was wrong, plainly wrong, and the court should consider the matter afresh. The first one is that the judge erred as a matter of clear law in conflating, confusing, the issue he had to decide under section 3.2 of the Act with the issue he had to decide under section 3.3 of the Act.
We didn't have to decide the question under 3.3.
Precisely. So he imported into his section 3.2 issue matters which were only relevant to the question under section 3.3, with which he wasn't concerned. And we say that is fatal. The judge, our second point, is the judge was wrong in law and in fact to classify Mr Corbyn's statements as bare comment and therefore they were to be treated as statements of fact rather than statements of opinion. We say he was both in law and in fact wrong, plainly wrong about that issue. Because we say the statements Mr Corbyn made were clearly not bare or naked, whichever word one wants to use, bare or naked comments. They were just clearly comments. And then thirdly, the judge failed to adopt the correct approach to deciding whether the words complained of were fact or comment. Now, our third ground...
Sorry, just say that a little more clearly.
The judge failed to adopt the correct approach to deciding whether or not the words were fact or comment and was plainly wrong. Now, it's important I emphasise that the third ground only comes into play if the court concludes that the judge was not in fact deciding, or did not in fact decide that the words were statements of fact because they were bare comment. So, in other words, if the court decides that what the judge was actually doing was referring to bare comment, but his ultimate decision was these statements are clearly statements of fact, not because they're bare comments and therefore to be treated as statements of fact, but simply because they are statements of fact. If the court gets to that point, and we say the court shouldn't get to that point, but if the court does get to that point, then our third ground comes into play.
So 3 is an alternative to 2?
My lady, I wish I'd expressed it as simply yes. So I submit we don't need to get to 3, but it's there, as my lady, the President says, as an alternative if I fail on 1 and 2 for the reasons that I've said, that the court concludes the judge wasn't actually getting involved in bare comment, although we say it's absolutely clear from paragraph 88 that that's precisely what the judge was doing. Have I made that clear, my lord?
Yes.
Perhaps I'll return to that.
It's quite compressed reasoning in 88, isn't it?
My lord, it is, yes. I mean, we say...
I mean, we always congratulate judges for compressed reasoning.
So it's not unusual in meaning and in decisions such as this for there to be a conclusory paragraph of this nature,
yes,
because it is, after all, just a matter of impression in the end.
My lady, it is.
Once you start to unravel it, you run into the problem that you're then criticised for being overcomplicating things. So
there is the difficult balance in trials of this nature, and from the advocate's point of view as well. One doesn't want to overburden the court with authorities, submissions, etc. And I have no doubt judges are in a very difficult position when deciding this. And we don't criticise the judge for the compressed reasoning, although it does require a bit of unpicking. But in essence, we say what clearly happened here was that the judge was persuaded by my learned friend, Mr Bennett, that these were statements of opinion. Sorry, he wasn't persuaded of that by Mr Bennett, but the judge clearly decided these were statements of opinion. But, agreeing with my learned friend Mr Bennett's submissions, they were simply, or they were bare opinion. So they were opinion.
Well, that's your ground too.
But they were bare opinion, and therefore they were to be treated as statements of fact. My lady, it is my sub-ground 2, but it also involves sub-ground 1, because we say the concept of bare comment simply does not arise on section 3.2.
I mean,
it is no longer, sorry, it is not a section 3.2. Bare comment is not a section 3.2 issue.
Yeah.
It is only to the extent the principle of bare comment survives the enactment of section 3, and I don't need to argue either way today, although we have very real doubts about it, but to the extent the principle of bare comment survives the enactment of section 3.3, it can only come in survives the enactment of Section 3, it can only come in at the Section 3.3 stage.
Yeah, no, sorry, but I just wanted to say, if he'd stopped after the first sentence in paragraph 88, you wouldn't have a ground 1 or ground 2. You'd only have ground 3.
I'd be then very unhappy about the lack of reasons there, my lord.
Okay.
I'd suggest that maybe is a bit too compressed, because we just simply wouldn't know.
But I mean, since you're looking at it from the point of view of the reasonable viewer,
Yes.
You know, as my reasoning just muddies the waters.
Well,
I mean, obviously you'd be able to say he was plainly wrong,
yes.
which is what you would say.
We do, yes.
Yeah, but I mean, all I'm saying is that he on one analysis, he has muddied the waters by that extra sentence,
Yes.
which were previously crystal clear in his first sentence.
Well, my lord, yes, I agree with respect, he's muddied it, but only in the sense that he has sought to give an explanation for his decision. And we are taking that.
He's saying, as to the submission, that Mr. Corbyn was merely expressing a view on conduct.
Yes.
So he said it's clear that he was making factual allocations as to behaviour, and as to the submission that he was merely expressing a view on that behaviour, if I can paraphrase, this is a classic case of bare comment.
Yes.
Yeah.
So we can only work with what we've got, and it seems to us it is clear from that sentence that the judge was relying on the concept of bare comment to reach the conclusion that these statements were to be treated as statements of fact.
You see, I'm not sure you're right. I mean, I'm looking at this perhaps as a black letter lawyer, but actually, the second sentence is irrelevant, because he said in the first sentence that it is clear that it's factual allegations as to behaviour. And then he says, well, they say something else, but even if that was something else, it's a bare comment. So it looks to me as if he hasn't actually given that as a reason for the first sentence.
Well, my lord, the reason we take it as meaning that what that does demonstrate his reason, because he says this is a classic case. So he makes a finding there that it is a classic case of the bare comment type.
Well,
so
but
my lord, that
could be badly expressed in that sense, because of what goes before. I mean, I acknowledge we're now trying to construe a judgment as a deed, which is an extremely unfortunate and unhelpful thing to do.
Yeah.
But if one is doing that, he is taking as his premise for it being bare comment the submission, not the fact that it is comment at all.
Yeah. Well, my lord, as my lord appreciates, the exercise I'm engaged in, it is trying to demonstrate the route for this court to consider this matter afresh. And we say all three of our grounds, stroke subgrounds under this ground, allow this court, and we say the court should consider this matter afresh, either because the judge erred in the first two ways that we say he did, in reliance on bare comment, the principle of bare comment, or if we're wrong about that, as my lord, the Master of Arose has indicated, we might be wrong about that, then we say in any event we come to our alternative submission, as my lady the President observed, he was plainly wrong. But
that's what I'm getting at, really. I'm struggling to, I mean, in a sentence, tell me why you say he was plainly wrong.
Oh, because
leaving bare comment aside.
Bare comment aside. Because as we submitted before Mr Justice Saini, to say someone is disruptive at a political event is obviously comment. It is obviously, we say, a description of something they were doing during the course of that event. It doesn't say what they were doing. And there is an enormous range of what could constitute disruption at a political event.
And what about very, very abusive?
My Lord, well, the words very, very, we submit don't really add very much. And the question is abusive a statement of fact or a statement of opinion? And we say it is, again, in the context in which Mr Corbyn was speaking, which is critical to remember, in the context in which you speak, to say Mr Millett was abusive, again, suggests or could cover a whole range of behaviour. So, what Mr Corbyn doesn't say, so this is in the context of Mr Millett speaking to Mr Hassasian after his speech. And this is important context, my Lord. He says, Mr Hassasian makes a speech, a powerful, passionate and effective speech about this controversial issue. During that speech, Mr Millett sits quietly. After the speech, Mr Millett berates, that's what he says in the 2013 speech, but the viewer will have that in their mind, berates. Then he says they were really, really strong on him. Then he says they were very, very abusive. Now, the viewer will think, well, he's describing Mr Millett's behaviour, but he's not telling me what Mr Millett actually did. It could be from having a heated exchange, from exchanging strong words, hence the really, really strong way. It could be punching him on the nose. It could be a whole...
It could be, but it normally, naturally, wouldn't. It doesn't sound like that.
Precisely.
No.
It's very unlikely a viewer would think that's where it was, because one also looks at the way Mr Corbyn talks about it during the interview with Andrew Marr. He's clearly not talking about this in a way which is suggestive of physical violence.
I mean, I would put it this way, Mr. Hudson. I mean, the way it could be that he was abusive in the sense that he said just a stream of abuse, bad words, say.
Swearing.
Yes. Or it could be that he was abusive in the sense that he put his argument abusively. In other words, he said, you're a bad person because you believe this and I believe that, and that makes you a bad person, or whatever. I mean, both would be potentially abusive, but they would be very different things.
Precisely.
And you, I think, say it's the second. It must have meant the second.
No, my Lord, I don't.
You don't.
Our point is simple, and with respect, I entirely agree with my Lord's analysis, which is always a convenient position to be in. But we simply say there's a range, and a viewer would appreciate there's a range. And a viewer watching that, if one watches that, the question is immediately, well, what did he do?
Why does it matter that there's a range? What significance does that have in this context?
Because
you can have a word that describes certain conduct, which could cover a range from A to Z of seriousness. Why does it matter?
Because in this case, a viewer would appreciate that Mr Corbyn was describing behaviour, was expressing his opinion or judgment about what Mr Millett had done, without telling the viewer what Mr Millett had in fact done. And because he didn't tell them what he had in fact done, the viewer would think, well, what did he do which Mr Corbyn is describing as being really, really strong on him, or abusive, or berating him? Berating can mean all sorts of things, from chiding someone to scolding someone in different ways. As my Lord and Master Rose says, it could be speaking aggressively, it could be swearing, it could be threatening, it could be intimidating. A viewer doesn't know, but the viewer will ask themselves, well, what was Mr Millett doing? And as soon as one is in that situation, it is obvious, we say, that the speaker is expressing an opinion, his judgment about what he saw happen. And then he is applying the epithet of really, really strong or very, very abusive to what he saw in that situation. And that will be obvious to the viewer. So, A, which means it's opinion, and B, which means the viewer, and I'll come on to this on the question of defamatory tendency, the viewer won't be able to make a decision, not properly anyway.
Well, what Mr Corbyn was trying to do was to explain why he used particular words. That was the question that he was answering.
My lord, yes.
So was it his opinion at the time that he was describing about Mr Millett's behaviour, or was he describing his opinion at the time of the interview? What's your case about that?
Well, my lord, I don't have a positive case on that, because he could be doing both or either. And we would submit that it doesn't, on either basis, it doesn't preclude it from being obviously an expression of opinion.
No, I was just trying to get clear
to a
the
viewer.
shape of the argument.
To a viewer. Well, as my lord observes, and as I said at the outset, this exchange starts with Mr Marr saying to Mr Corbyn, strange thing to say. So Mr Corbyn appears to be explaining why he said what he said in the 2013 speech. And it's in the context of very strong suggestions that he is anti-Semitic, and that his speech in 2013, which some have described as the irony speech, that speech was anti-Semitic. And he was seeking to explain why he made that speech, why he said that at the time. And so, in answer to my Lord Justice Warby's question, it seems to me this may become a factual issue which we would have to address at some point.
Well, I wasn't asking, what I was asking was what the impression that the reader would get, what are the cases on that? That's
well, my Lord,
the relevant issue for our
my submission would be different viewers might get a different impression. Some viewers are likely to think, well, this is Mr Corbyn in September 2018 expressing his opinion about what happened in 2013. Or a viewer may think it's Mr Corbyn in 2018 expressing his opinion about what was actually going on at the event in 2013. Or events, I should say, in 2013. But on either basis, we say it would be absolutely clear to a viewer that these were all of these phrases, berating, which is in the 2013 speech, really, really strong on him, very, very abusive, quite upset by it. All of those a viewer would fully appreciate were expressions by Mr Corbyn of his opinion, of his assessment, his judgment, criticism, all of those words that my Lady the President cited with approval in Butt. That's what he was doing, and a viewer would fully appreciate that. He was not making a statement of fact that Mr Millett did X or Y, namely, for example, and there's no suggestion this happened, that he swore at Mr Hassasian, or my Lord the Master Arose didn't like my example, punched him on the nose.
Well, no, because that's of a different order.
It is.
But your case, as I understand it, is that Mr Corbyn's statement was conclusory. He concluded that he was being very, very abusive. So that's one of the words my lady used, conclusion.
Yes.
The alternative view, perhaps supported by the very, very abusive, is that he was very, very abusive. In other words, very, very using bad language, very, very doing something factually bad. And it seems to me those are the competing positions. And you're right to say that one has to look at the whole thing and see what the impression you gain from it. But you also have to go so far as to say the judge really couldn't reasonably reach the other conclusion, do you not?
Well, on this third subground, I do, my lord. Yes.
Yes. Yes.
We say he couldn't reasonably reach this because it was to say, for just picking up on Lord Master Earl's point, very all that adds we submit is saying he was abusive to a higher degree, or to a high degree.
Well, of course that's right, but there is an impressionistic element to that.
Yes, but it still comes back to this question: what is meant by abusive? What is that? What is that describing? What really strong? What is that describing? It's describing behaviour.
No, speaking only for myself, I think really strong helps you, because I think really strong gives the viewer the impression that it is a really strong exchange of opinion that he is saying. So he was really strongly expressing opinions, which, well, if it doesn't help you on this point, it maybe helps you on the next point. I mean, I think the really strong is a help, because it does reduce some of the ambiguity about what abusive meant.
Well, yes.
What I mean, that's speaking only for myself, and just an impressionistic view. But abusive is the word I find most difficult in this case. I mean, I'd be quite honest with you. I find abusive the most.
Well, yes, and it seems to us that that is a particular application when one considers the question of defamatory tendency. But on the question of opinion or fact, I come back to the point that a reasonable viewer would understand that these were descriptions, these were epithets. At worst, that these were inferences of fact, or statements of fact inferred from behaviour, which still amounts to opinion, as my lady the President has referred to in Bath. But when there is a significant distinction, we say, between saying somebody did something, saying specifically what they did, such as he was swearing, he was using the most foul language, or he was swearing using the most foul language, he was threatening to assault him, those sorts of things, which are much closer to statements of fact.
Well, those would be facts, wouldn't they?
I don't. Most likely, I wouldn't want to say in every scenario they would be, because
not in every scenario, but generally, it's like my shouting example. I mean, if you say shouting, well, people may have different perception about shouting, but actually, it's a fact. Was he shouting or not shouting?
Yes. So, if we were in that territory, we wouldn't be here.
No.
But we're not, because it's so. One inevitably, I realise I'm repeating myself, and I hope the court will forgive me, particularly when I haven't even got onto my points yet. But one comes back to the point. A viewer would inevitably ask the question. I'm not saying this is the test, but it occurs to us that if a viewer sits there and thinks, what did he do? What did he do that was abusive? We're confronting my Lord's most difficult word. What did he do that was abusive? Inevitably means the viewer doesn't know what's being said. What the viewer knows is Mr. Corbyn saw something happen. He saw Mr. Millett behave in a certain way towards Mr. Hassasian after he spoke. And Mr. Corbyn characterised that as being very abusive. But the viewer does not know what the underlying facts are. And those are, if the honest opinion defence runs in this case, then that will become a question of relevance to the other conditions in the defence.
Well, what I've written down, and I wonder if this does really encapsulate your submission, is you look at this from the reasonable viewer. If the reasonable viewer thinks about what Mr. Corbyn was saying Mr. Millett did that was abusive, he can't know the answer. He only knows that Corbyn thought it was very abusive. And that is an opinion, you say.
My Lord, yes.
I mean, is that a reasonable way of putting it?
My Lord, I pounce on that, yes.
Yeah, thank you.
My Lord, I had 3 preliminary points.
Yes, carry on with them and I'll shut up.
But I suspect I don't need to deal with them other than just to list them. My 3 preliminary points were the importance of the defence of honest opinion. The second one, what is opinion? And the third one, what is the correct approach to determine the issue? The determination of the issue as a preliminary issue. And now I take those 3 points very briefly, just so that the court knows what I was going to say. On the first one, importance of the defence, in fact, I already said in answer to my Lord Justice Warby's question, it's an essential part of the protection afforded to freedom of expression. And in support of that, we cite the following authorities. And I don't know if that would help the court for me just to list those.
Yes, tell us what they are.
It's my Lord Justice Warby's judgment in Yo against Times Newspapers Limited, tab 8, and the paragraph is paragraph 15. My Lady the President's judgment in Butt, tab 18, and it's paragraphs 25 to 27. And my lady there said, amongst other things, that it's recognised it's the bulwark of free speech, and the limits of the defence are very wide. And then we say it applies with particular force when the speech involved is political, which we say this clearly was. And we get that from the decisions of the European Court I've referred to, but also as referred to in the decision of Supreme Court in Joseph against Spiller, which is at tab 5, and particularly the speech of Lord Phillips at paragraph 78 to 79, in which he cites the Frico against Slovakia case. Again, my Lord Justice Warby in Yo at paragraphs 15, 93 and 97, and my Lord Justice Warby in Barron and Collins at that's tab 10, at paragraphs 12 and 18. And as I said earlier, I made the point which my Lord Justice Warby had made in Yo about the court giving free rein to comment. And we very much emphasise that on this appeal and submit that that applies with particular force in the situation in which Mr Corbyn found himself and the language that he used. The second preliminary point is what is opinion rather than fact, and I simply need to refer to my Lady the President's judgment in Butt and the classic dictum of Mr Justice Cousin in Clark and Norton, which my Lord the Master of the Rolls has referred to. And we make the point, although it seems to us it actually assists us in this case, the question of verifiability, but we do make the point that the statement does not have to be unverifiable for it to amount to comment, although in fact we say in this case it was, because to describe someone's behaviour as really, really strong or abusive is not something that's actually capable of verifiability, because it is simply a question of a person's view of particular conduct or behaviour. And then my third issue was the correct approach to determination of this as a preliminary issue. But I think I've dealt with that already when I made the point that actually the question is whether the correct question under Section 32 is whether the statement complained of is opinion or fact rather than the meaning, if this court is going to consider the matter afresh. And I can deal with that in more detail if it would assist the court as to why we say that. We say it's simply clear from a clear construction of the statute. That is the only issue under Section 3.2. But it's also the position that appears to have been adopted in relation to the similar words, same words used under Section 4 of the Act. So, my lords, my lady, those are my 3 preliminary points. And then I was proposing to deal with my 3 sub-grounds. But we have largely covered those, and it may be whether the court feels it could benefit from further assistance on those 3 grounds, or is satisfied that the 3 issues have been dealt with. I'm conscious I haven't properly dealt with the first 2 points we make as to the judge conflating and confusing Section 3.2 and the Section 3.3 issues. And secondly, in any event, this was not a bare comment, both as a question of fact and law.
I think you should.
I'm grateful.
Speak for myself. I think you should develop them.
I'm grateful. So, turning to that first issue, wrongly conflating. In summary, we submit, as I think I've already said, that the concept of bare comment does not apply to the issue to be determined under Section 3.2 of the 2013 Act. To the extent that the principle of bare comment survives the enactment of Section 3, the honest opinion defence, it will only come into consideration when the court considers the issue under Section 3.3. And our reasoning for that is as follows. The issue under Section 3.2 is solely, and this is what was intended to be determined by Mr Justice Saini, is solely, as we've already discussed, whether the statement complained of was a statement of opinion. The issue under Section 3.3, which was not before the learned judge, is whether the second condition of the honest opinion defence is satisfied, namely whether the statement complained of indicated whether in general or specific terms the basis of the opinion. And that question does not, as a matter of plain statutory construction, that question does not come into determination of the first condition under Section 3.2.
So does it follow that Mr Justice Nicklin was wrong in subparagraph 5 of his 5 points that were cited by the judge?
My Lord, if and to the extent Mr Justice Nicklin was holding that, I wonder if it would help to turn that up. It's I assume my Lord Justice Warby is referring to Mr Justice Nicklin's decision in Cutso Giannis.
Well, I was referring to it as replicated in paragraph 83 of the judgment, where
Oh, I see.
that the judge applied was set out. I'm just a little unclear of what happened below, but anyway, these are the principles the judge applied. They were contained in a judgment.
Yes.
Justice Nicklin that postdated the Act.
Yes.
And so it seems to me inherent in your submission that Mr Justice Nicklin and that his decision on this point shouldn't have been followed.
Well, to be fair, this issue was dealt with relatively briefly before Mr Justice Saini. I should obviously answer my Lord Justice Warby's question first before I proceed with But my answer is, if Mr Justice Nicklin was saying Kutso Giannis, which is at tab 14 of the authorities bundle, and it's paragraph 16. My lord, it's page it's tab 14 of the authorities bundle, page 319.
Yeah, I've got it, thanks.
And there are 5 principles set out there, and it's principle 4. Some statements which are by their nature and appearance opinion are nevertheless treated as statements of fact, etc. If and to the extent that, and I don't believe it was argued in Kutso Giannis as far as I'm aware, but I wasn't in it, but as far as I'm aware, from the judgment it doesn't appear to have been argued. If and to the extent Mr Justice Nicklin was there ruling that that was a question which was relevant to the determination of the section 3.2 issue, then we say with respect, yes, he was wrong. But I'm not aware that that point was even argued.
Well, it wasn't indisputable.
No.
So Mr. Rushford, Mr. Santos, and Mr. Margaret were all in agreement with that.
Yeah. Well,
but it may not have been a point that mattered to
no,
their case.
no. And in this case, it was dealt. It was the issue of bare comment was dealt with very briefly. There was a reference to it in my learned friend's skeleton argument. I think at paragraph 48, my learned friend referred to yes, it's paragraph 48 to the extent it matters, but for my lord's and my lady's note, it's at paragraph 48 of my learned friend's skeleton argument for the trial and preliminary issue, and that is in supplementary bundle tab 6. Page 60. There's simply a reference. All it does at 48 is cite paragraph 16.4 of Kutso Giannis. There's no argument there. Then at the hearing, Mr. Bennett, my learned friend Mr. Bennett, advanced the argument that to the extent these statements were opinion, they were bare opinion or bare comment, in the sense of subparagraph 4, 16.4 Kutso Giannis. Our response was these are not statements of bare comment, and this is an issue. I didn't submit that 16.4 Kutso Giannis was wrong, but it is clear we submit from a proper construction of section 3.2 and 3.3. Bare comment principle simply cannot arise under 3.2, and we
well,
say.
Isn't it just what might be said is that this is not a rule of law, but a point, which is I think the word that Mr. Justice Nicklin used, about how words usually strike the ordinary reader.
Well, my lord, there is, if I may say so, we certainly have some difficulty with the concept of bare comment in terms of what precisely it is. It appears to be, and have been treated as, a principle and effectively a rule of law. Going through the history of it. And,
well, it's Kemsley and Foot, isn't it? I mean, that's where
my
it
lady,
comes
yes.
from.
My lady, yes.
Oh.
And it was examined in detail in Joseph and Spillett. And the position seems to be, and I'm summarising and paraphrasing, the position seems to be that where there is a statement, which is clearly a statement of opinion, such as Hudson is a disgrace to the bar, although that is clearly a statement of opinion, it is treated as a matter of law as a statement of fact if there are no facts indicated as part of that statement to explain the basis on which the speaker says that about Hudson. And that is our understanding of the principle or rule of bare comment, bare opinion. And that can be trapped through all the cases, as my lady, the President says, from Kemsley and Foote right through to Joseph and Spiller. And critically for these purposes, that principle specifically was enacted as Section 3.3 of the 2013 Act.
Yeah.
And what we sought to do is set out in the skeleton argument we set out a series of paragraphs about the legislative history. And what happened was, when the 2013 Act, the bill was prepared and drafted, there was no equivalent of Section 3.3 in the draft bill. And complaint was made, or concern was raised, that if one only had Section 3.2, that would allow the defence of honest opinion to apply to bare comments, bare opinions. And it was suggested that that was not appropriate and something should be done about it. And the government considered that issue and agreed with it, and that led directly to Section 3.3. And I can take the court through the legislative history as we've set it out.
Well, let's assume that's right, Mr. Hudson.
Yes.
I mean, are you saying that really the problem here is not with what Mr. Justice Nicklin said, but with dealing with one without the other? Because you can decide something is prima facie an opinion under 3.2 and then go to 3.3 and find that it's a bare opinion and therefore a fact. So very difficult to deal with one without the other.
My Lord, yes. And
But I mean, that if you agree with that, then you're not saying that Mr. Justice Nicklin was really wrong. You're saying that he was really right.
well, that's why I was careful, my Lord. I clearly wasn't careful enough. I was trying to be careful to confine it to the Section 3.2 question. And we don't think that's what Mr. Justice Nicklin was saying, that the bare comment principle applies to Section 3.2. He just wasn't confronted with that.
No, but if he was saying what I've just said he was saying, then maybe he was just saying the point that my Lord mentioned.
Absolutely. My Lord, we entirely accept that the concept of bare comment is alive and kicking.
Yes.
But it's in Section 3.3.
Yes, but I mean that's a sort of doesn't get you anywhere, because even if the judge, the judge was entitled, wasn't he, to say you are not within 3.2 because it's a bare comment which makes an opinion into a fact.
No, my Lord, with respect, no, he wasn't, because we submit on the correct construction that would have been the Section 3.3 question for him.
But isn't the question one of the questions that you have to look at when you're deciding whether it's comment or fact, or traditionally that's been the approach, is something which enables the viewer, in this case, to see that what you're doing is actually commenting. And if you make let's call it a bold statement for the present purposes, that can give the appearance of it happened, rather than these are the facts and this is what I think about it. And that's one of the reasons why this approach was one of the lenses through which the question, fact or comment was viewed.
Well, my lady...
And that goes back to Hunt and Starr.
My lady, yes, but we say that issue, that discrete issue, is now the question under Section 3.3. And so, in answering the issue under Section 3.2, one decides whether or not, from the perspective of the ordinary reasonable viewer in this case, would understand that the statement was an opinion. One doesn't go on to decide or consider whether it's a bare comment and therefore to be treated as, via a legal fiction, treated as a statement of fact.
He's not saying it's a legal fiction. What's being said is because it is a bare statement, which might otherwise, if there were a foundation for it, be treated as an opinion, it is actually treated as it is actually regarded by the reasonable viewer as a fact. So if, for example, you said he is stupid,
Yes.
right? We all think naturally that would be an opinion. But if you just said he was stupid with no foundation for it, that might be a bare opinion. I mean, I'm speculating here because, and I'm not declaiming this to be the case, I'm just saying. But if you said he's stupid because he thinks that the world is flat, then you'd given a reason why you think he's stupid, because he thinks the world is flat. And if he did, whether or not he thinks the world is flat is probably a fact.
Yeah, my lord.
So if you just say he's stupid, you might be in danger of having expressed a fact.
Well, my lord, I accept. I can't immediately think of one, but I accept that there may be a situation in which, obviously in deciding how a viewer or reader would regard the statement, whether it's a statement of fact or opinion, one takes into account all the surrounding circumstances. One takes into account what was said, what was left unsaid. And so that there may be situations in which a statement such as he's stupid, although I struggle with this, would be understood to be a statement of fact rather than a statement of opinion. Well, I would tend to the view that normally that would be regarded as a statement of opinion. So, but I'm not suggesting that as part of deciding whether the ordinary reasonable viewer considers something to be fact or opinion, one takes into account all the surrounding circumstances, of course, and what is said or left unsaid. But that isn't an application of the principle of bare comment or bare opinion. That is just the way in which one determines, in accordance with the principles, the very well-known principles, whether something is a statement of fact or a statement of opinion, or whether a reasonable viewer would understand something to be a statement of fact or a statement of opinion. The principle of bare comment, we say, is something very different. We submit it is a legal fiction or a legal construct which the courts have developed through the history of this to say, well, yes, it is a statement of opinion, but the courts will treat this as a statement of fact because the commentator has not provided a sufficient indication of the facts or the background to this. And perhaps I'll take the court to Spiller in a moment. And that is the principle of bare opinion. And on that basis, the statement, although it is clearly a statement of opinion, is to be regarded as a statement of fact. And we say that principle has been carried into, expressly enacted into section 3.3. And one gets that from the legislative history, which we have set out in detail at paragraph 24 onwards, page 6 onwards of our appeal skeleton argument.
Is it? It's not enough to look at the explanatory notes to the act.
My lord, it may well be.
Because what they seem to say is that Cheng is the main foundation of the statute.
Yes.
And the
paragraph 22 of the explanatory notes.
The first condition reflects the requirement that the statement should be recognisable as comment. And it's in that context that the bare comment or bare opinion rule has grown up. The second condition reflects the separate requirement identified in Cheng, which is the comment must explicitly or inferentially or impliedly indicate the basis of the comment. So
yes.
In the explanatory notes that you are
Well, my Lord, we contend that on an analysis of Joseph and Spiller, and I can take the court through that, on an analysis of Joseph and Spiller, we submit it is clear that the principle of bare opinion is, I'm slightly getting ahead of myself, my Lord.
Sorry, I'm taking that.
The court knows what I'm saying. That proposition 4 of Lord Nicholls' propositions in Chain is what it covers the bare comment principle, and it's that which is enacted into section 3.3. And the second proposition, which my Lord Justice Warby refers to, is not does not cover the bare comment principle. Perhaps I take the call to Joseph and Spiller. Joseph and Spiller is at tab 5 of the Joint Authorities Bundle, page 169. It's at 2011, one appeal case is 852, decision of the Supreme Court. I'm sure the court's familiar with the background facts, which in any event aren't of significance for this issue. But what happens at paragraph 3 and the end of paragraph 2 at page 858 of the judgment, page 92 of the electronic bundle, Lord Phillips sets out a detailed analysis of the current elements of the defence of fair comment and starts at paragraph 3 by setting out the propositions set out by Lord Nicholls in the Court of Final Appeal of Hong Kong in the Chain case, my Lord Justice Warby referred to. Now, the court will see there are five propositions which are listed at paragraphs 16, 17, 18, 19, and 20 of Lord Nicholls' judgment. The two of particular significance for these purposes are the second one at 17 and the fourth proposition at 19. And as my Lord Justice Warby said, it's the second proposition at paragraph 17, the comment must be recognisable as comment as distinct from an imputation of fact. Now, my submission is that is obviously the critical issue, but that is the section 3.2 issue. It is not the section 3.3 issue, and it does not involve the question of bare opinion, which is it's a separate principle, which although it appears to have been referred to in proposition 2, is in fact expressed fully and properly in proposition 4. But as Lord Nicholls says at 17, if the imputation is one of fact, a ground of defence must be sought elsewhere. Much learning has grown up around the distinction between fact and comment. For present purposes, it is sufficient to note that a statement may be one or other depending on the context. Mr Justice Ferguson gave a simple example in the New South Wales case of Meyerson. Quote, to say that a man's conduct was dishonourable is not comment. It is a statement of fact. To say that he did certain specific things and that his conduct was dishonourable is a statement of fact coupled with a comment. And then, I won't go to it straight away, but that observation of Mr Justice Ferguson is then criticised by Lord Phillips further in the judgment. We'll come to that in a moment. Fourth proposition at 19. Next, the comment must explicitly or implicitly indicate, at least in general terms, what are the facts on which the comment is being made. The reader or hearer should be in a position to judge for himself how far the comment was well founded. Now, it is that proposition, proposition 4, which is then modified by Lord Phillips and the Supreme Court in this case, and which in its modified form is enacted into section 3.3 of the Act. and we say it is that proposition which is in which the principle of bare opinion, bare comment, is embodied.
Is the if you had a statement which had a series of facts in it, and the person then said, and therefore without using the word, my conclusion is X or Y, the context would give support to the submission that was an expression of opinion.
My lady, yes.
The bare fact issue on one view, bare comment issue, I should say, on one view, is the converse of that. If you don't, if it simply stands on its own, then it's more difficult to persuade or for the viewer to perceive it as an opinion as opposed to a bald statement, is what I said before.
My lady, yes, but it's
that's a separate question from the 3-2 question.
It is, my lady, and it is our understanding that the principle of bare comment doesn't apply to the situation my lady just postulated. That situation is a quite separate one, and it's a not so straightforward issue there. Well, how would the viewer see that? Would the viewer understand that to be comment or a statement of fact? One doesn't get into the question of bare comment, bare opinion. The principle of bare opinion only arises where the statement would be understood by the viewer as opinion. It only arises in that situation. It's not where,
so it's not to do with how you characterise the
no,
comment.
no. It is a principle of law. It's a construct, which is it's not about how the reasonable viewer would understand the statement. It's not how that. It's not a way of saying this is how a viewer would interpret it. It is a legal construct to deal with the situation the courts were confronted with, which is as follows. Some statements, such as Hudson as a disgrace to the bar, is clearly a statement of opinion. And Lord Phillips gives the example, and I'll come to that in a moment, of the disgraceful barrister. They're clearly statements of opinion. But the courts have decided they should not be defensible as honest opinion because they don't, despite being opinion, they don't provide or give an indication of the supporting facts. And therefore, common law were treated as statements of fact. But more accurately, I should say, they were not.
Why should that be so? And what's the principle which would support that as a justifiable restriction on freedom of expression?
Well, as dealt with in Joseph and Spiller, and then as dealt with in the 2013 Act, the idea behind it is that a viewer or reader should be in a position to form some sort of judgment as to the nature of the comment, the validity of the comment. Not that they have to be able to be in a position to form their own view, and that was the issue in Joseph and Spiller. And the Supreme Court, as my lady knows, in Joseph and Spiller decided that isn't a requirement of the honest opinion defence, but that I'm going to jump around, if I may, to get to the conclusion in Joseph and Spiller, and then I'll come back to the other parts that I need to. What paragraphs 104 and 105, which is at page 120, Lord Phillips says, I do not consider, this is just above B at 886 of the report, I do not consider that Lord Nichols was correct to require that the comment must identify the matters on which it is based with sufficient particularity to enable the reader to judge for himself whether it was well founded. The comment must, however, identify, at least in general terms, what it is that has led the commentator to make the comment, so that the reader can understand what the comment is about, and the commentator can, if challenged, explain by giving particulars of the subject matter of his comment why he expressed the views he did. So that is to answer my lady, the President's question, that is the rationale for it. And then the consequence of that is at 105, where Lord Phillips says, I endorse Lord Nichols's summary of the elements of fair comment I've set out at paragraph 3 above, save that I would rewrite the fourth proposition as follows. Next, the comment must explicitly or implicitly indicate, at least in general terms, the facts on which it is based. And that becomes section 3.3.
Well, it does, but the issues on the appeal in Spiller are identified in paragraph 31. And they were all to do with what could be or could not be relied on in support of the defence of fair comment, which ex-hypothesized was open to them in principle because it was at least capable of being comment. So the court was not concerned with the section 3.1 or its precursor. Was it? And that's how I read it.
Section 3.2.
Yeah.
Sorry.
The first condition. In other words, they weren't concerned to decide whether these words were or were capable of being comment. The question was whether they could be defended or not because of the alleged insufficiency of the indication of the factual basis of the comment. So that was the issue.
Oh, precisely. Yeah. And it was in that context, and we rely on that, and it was in that context, so the section 3.3 issue, what is now the section 3.3 issue, it was in that context that the issue of bare comment comes up. And one can see that in particular from Lord Phillips. Sorry, I just want to remind the court of paragraph 5 of Lord Phillips, paragraphs 5 and 7 of Lord Phillips's speech, where he refers to the second and fourth proposition and indicates in 5 why it's not satisfactory to say someone's conduct is dishonourable as simply a statement of fact, because in fact, as Lord Phillips says at 5, just above D, page 859 of the report, page 93 of the electronic bundle, it is a comment based with an allegation of unspecified conduct and upon which the comment is based.
Could you read to the end of the paragraph?
A defamatory comment about a person will almost always be based either expressly or inferentially. A defamatory comment will almost always be based either expressly or inferentially on conduct on the part of that person. Judges and commentators have, however, treated a comment that does not identify the conduct on which it is based as if it were a statement of fact. For such a comment, the defence of fair comment does not run. The defendant must justify his comment. To do this, he must prove the existence of facts which justify the comment. It's fine. Then at 7, the fourth proposition is set out. It is this proposition that is directly an issue in this appeal. The facts on which the defendants wish to rely on support of the plea of fair comment include a fact to which they made no reference in the publication complained of. And then the discussion starts at page 882 of the report, 116 of the electronic bundle. And particularly at 87 and 88 deal with the concept of bare comment in the context of this appeal. Would the court like me to read 87 and 88?
Well, we can read it.
I'm grateful.
And 89 as well, isn't it?
And 89 and 90, my lord, yes. And then I'm afraid it runs right, in fact, runs right through to it runs right through to 104, I'm afraid. But the point I made about the barrister being a disgrace to his profession is dealt with at paragraph 103. So our submission is, although proposition 2 and 4 are linked, I accept they are, of course, linked in a sense. The principle of bare comment is not actually part of proposition 2, if I may use that shorthand.
The bare opinion point.
Yes, the bare opinion point is not an aspect. Well, it is an aspect of proposition 2 in the sense that where if a statement is a bare opinion, in the sense considered and determined by proposition 4, as a matter of law, it was treated as not coming within proposition 2, i.e. not being an imputation of comment. It was treated as an imputation of fact. But whether or not something is a bare opinion is a proposition 4 issue. And it is proposition 4 that has found statutory form in section 3.3. I realise I'm advancing a very...
For my part, I find that very helpful.
Oh, my Lord, I'm grateful. I feel as though I've convoluted myself, but I don't know if
the way I understand it, which maybe I don't, but the way I understand it is that something can be a statement of opinion to the reasonable observer within proposition 2.
Yes.
So, for example, it doesn't matter, can be an opinion, and then can become a fact by virtue of having failed to get through the second condition, if it is a bare opinion without any backup.
My Lord, yeah. At common law, yes. With respect, I agree. At common law, that was the position. So it had to be an opinion to begin with, otherwise the principle doesn't arise.
Yeah.
If it's a statement of fact, that's endgame. It's only if it's a statement of opinion. The viewer, the court goes through the exercise of thinking, how would the reasonable viewer understand this? The court reaches the conclusion, adopting that exercise, the reasonable viewer would understand this as a statement of opinion. However, as a matter of law, the courts will treat this as a statement of fact because it doesn't give a sufficient indication of the surrounding facts. I'm paraphrasing. That was the position at common law, albeit it was very rare that a bare opinion would actually happen in practice. It's now been enacted in statutory form in an attempt to make it clearer, which was the purpose behind Section 3 of the 2013 Act. It's now been enacted, put in statutory form and made clearer and more distinct. So it's clear you have the Section 3.2 question, which you decide that without any consideration of questions of bare opinion or bare comment. And if you are in my learn from Mr. Bennett's position, and you say, oh well, you can't rely on this opinion because it wasn't. Even if it was opinion, it was only a bare opinion. That is the question which comes into play at the Section 3.3 stage. And we simply weren't there before Mr. Justice Saini. So, my Lord, my Lady, I'm very conscious. I've probably not explained that anywhere near as simply as I might have done, or my Lords or my Lady would have done. But I think I've made the point as to why we say if, and we submitted, the learned judge did, if, and we say it's clear from paragraph 88, if the learned judge decided that Mr. Corbyn's statements were not a statement of opinion because he did not indicate, he implied what Mr. Millett had done, that he'd done something, but did not indicate what that something is, a type of bare comment. That is the Section 3.3 question. And he took that into account when he should not have done in deciding the Section 3.2 question. And if
I mean, I have to say the point I made earlier again, which is that really doesn't seem to be what he was saying in paragraph 88. In paragraph 88, he was finding very clearly that Mr. Corbyn was making factual allegations in the statement as to Mr. Millett's behaviour on more than one occasion.
Yes.
That is his finding. So we don't get to, I mean, it may be right, it may be wrong,
Yes.
but that's what he was finding.
Well, my lord, the reason we question whether that's all that Mr. Justice Saini was doing is because in a very short paragraph giving his decision and reasons on this issue, it would be very odd to make express reference to the principle of bare comment and the decision of Mr. Justice Nicklin in Christianus 16, paragraph 4, subparagraph 4, if that was not something he'd taken into consideration. Because, as my Lord the Master of the Rolls indicated to me earlier, he could have simply stopped after the first sentence. And we submit that if the learned judge did not take into account the question of bare opinion, he simply would not have referred to it, unless it was to say, it's been submitted to me that this is a question of bare opinion, but I do not consider that to be a relevant consideration because I find this is simply a clear factualisation. But the learned judge didn't do that. He expressly referred to it in a way which we submit, with the greatest respect to my Lord the Master of the Rolls, which we submit, it must be there for a reason. He must have put that sentence in to indicate something. Otherwise, as my Lord the Master of the Rolls said, it would have been odious. It just would have been no point in such a short judgment on this issue. He just wouldn't have said anything about it, or he would have mentioned it to reject it.
Well, I mean, obviously we're not construing it as a deed. We've been around this track before, but
I'll leave it there, my Lord.
I think I understand your submission very clearly, but I think an alternative proposition is that he was doing what he was saying he was doing, which is dealing with the submission that Mr. Corbyn was merely expressing a view on conduct, having dismissed that, saying, well, even if, so it's an alternative, even if it really, they're right to say it was a view on conduct, it would be a bare opinion.
Yeah. Well, my Lord, I'll only be repeating my submissions if I say anything further. So,
we'll have to think about it.
Yes.
It's quite difficult. Well, it's clearly for decision.
Yes, my Lord, so those are our submissions on this point that the learned judge, if he carried out the exercise we submitted did, he took into account irrelevant considerations because he really carried out the Section 3.3 exercise, or whether one wants to put it as a question of statutory construction or simply saying the learned judge took into account issues on bare opinion which were not relevant to the issue he had to determine. Our second ground, as the court is aware, was that in any event, if the learned judge did decide this on the basis that it was to be treated as a fact because it was bare opinion, he was wrong as a matter of law and fact to conclude that this was a matter of bare opinion. Now, I of course recognise that this submission fails for the same reasons as the first submission fails, if my Lord the Master of the Rolls' point that he wasn't actually carrying out this exercise is the decision of the court. Because this only runs if he was treating what was otherwise a statement of opinion as a statement of fact because he regarded it as bare opinion. And we say, if that's what he was doing, acknowledging the observations of my Lord the Master of the Rolls, that he may not have been doing that, if that's what he was doing, he was wrong as a matter of law and fact to do that, because we say, on a proper analysis of the law as to what amounts to a bare opinion, both at common law and under Section 3.3, this clearly was not a bare opinion being expressed by Mr Corbyn. It's a quite separate issue from the statutory construction point, if I can call my first subground. And the easy way to summarise that point is simply by saying, if that's what the learned judge was doing, then what he was actually was carrying out the Section 3 exercise. And so the question is, was he right that for the purposes of Mr Corbyn's comments did not satisfy the requirements of Section 3.3? Now, he wasn't actually carrying out that exercise, I accept that. But that, we say, that would be the appropriate test, because the question of bare opinion now has statutory form in Section 3.3. So one can either take it from the test from Section 3.3, or from paragraph 105 of Lord Phillips and Joseph and Spiller, namely, the comment must explicitly or implicitly indicate, at least in general terms, the facts on which it is based. So our submission here is that the judge was wrong in law and in fact to conclude that this was a bare opinion, because Mr Corbyn's comment or statement did explicitly or implicitly indicate, at least in general terms, the fact on which it was based. It's the same question whether one does it by reference to 105 of Joseph and Spiller or Section 3.3. And our short point about that, it is clear from when one looks at the programme and all the transcripts that it was clear, at least in general terms, the facts on which Mr Corbyn was basing his expression of opinion about the behaviour of Mr Millett, because he was seeking to explain what had happened at the meeting in 2013, and seeking to explain why he had spoken the way he did at the meeting in 2013. He was seeking to explain the way, and this was obvious to the viewer, he was seeking to explain the way in which Mr Millett, according to Mr Corbyn, had behaved at a number of meetings, i.e. he'd been incredibly disruptive at a meeting in the House of Commons, he'd been disruptive at a number of other meetings, and about his behaviour at a meeting at which he berated Mr Hassassian. So all of those facts were before the viewer. And those were all the facts that Mr Corbyn was basing his statement of opinion on. So we say very simply and shortly that it is clear, when one looks at the programme properly and the transcript properly, that the viewer would be aware of what this was about. This cannot sensibly be regarded, we submit, as a bare comment or a bare opinion in the way properly understood and set out by the authorities, including Joseph Spiller and now in Section 3.3. It wasn't a simple statement without more that Mr Millett had done something with no more. The viewer would understood the background facts, the context, what Mr Corbyn was saying had happened, when, and it was clear to the viewer that that was Mr Corbyn's opinion. And picking up on paragraph 1 104 of Lord Phillips and Joseph and Spiller, it identified in general terms what had led Mr Corbyn to make the comment, so that the reader can understand what the comment is about. That's obvious. And the commentator could, so therefore Mr Corbyn could, if challenged, explain by giving particulars of the subject matter of his comment why he expressed the views that he did. And that's what will have to happen in reality if the honest opinion defence proceeds. Mr Corbyn will be required, as part of setting out his defence and pleading this honest opinion defence, to give particulars of the facts on which he based his comments. So we say that this judge was just plainly wrong on this, to characterise this as their comment. We say it's actually an argument. That then takes me to my third point. And this was, as my Lady President said, my alternative. But now, in the light of the observations of my Lord the Master of the Rolls, is becoming a particularly important point. This is our point that if the learned judge simply decided that these were factual allegations without any reference to or reliance on the concept of bare comment, so the learned judge said, look, I've been referred to the concept of bare opinion, but I'm not applying it here, I'm not taking it into consideration. These are simply and clearly factual allegations. We say he is plainly wrong. The court can be quite satisfied, very satisfied, however one applies the test. It's outside the range of reasonable views of a judge in this situation. When one looks at what amounts to comment, and I've referred to my Lady the President's judgment in Butt, all the relevant authorities on what can amount to a comment, we say it is clear beyond argument, we submit, that a viewer would understand what Mr Corbyn was saying about Mr Millett, including the very, very abusive, was a comment.
Well, I mean, this is where we come back to the point I made very early on. If I'm looking at the underlined words in the judge's judgment as the words complained of in paragraph 6, and just going through it briefly, the first sentence is all fact. The second sentence, I didn't. I mean, that's a fact.
But my Lord,
I said they should remain. So we get to the bits about disruptive and abusive as being the question of opinion. That's where you say it becomes opinion, right?
Well, my Lord, there's a reference to incredibly disruptive in the first sentence.
Yes.
I mean, my Lord.
Yes, sorry. Yes, you're sorry. You're absolutely right. The first sentence as well.
My Lord, I didn't advance this argument explicitly before Mr Justice Saini, so I'm very careful to even raise it now. But it does seem to us properly analysed, which then raises the question, why I didn't argue it properly before, but properly analysed. A viewer would realise that after the words "a strange thing to say," a viewer would realise what's coming next. In the context of that programme, what's coming next is Mr Corbyn's opinion, view, perspective, however one wants to describe it, whatever epithet one wants to use.
Well, why not explanation?
Explanation of what happened, of why he said what he said in the 2013 speech. This is really about, you're an anti-Semite. No, I'm not. Absolutely not. Well, here are some examples of why people think you are. Here's the 2013 speech. Strange thing to say. In parentheses, as my Lord Master Roll says, Explain it. How do you explain it? And that's what Mr Corbyn does. And viewers, intelligent, relatively sophisticated viewers would have realised that this was an explanation, whatever other epithet one wants to apply. This was opinion. But I raise that because it seems to us, having thought about this further in preparation for appeal, that is the correct analysis. I didn't put it explicitly like that before Mr Justice Saini, and I don't need to because, as my lady the President observed, much of this, we say any of the statements of fact here aren't actually.
But the fact that it's an explanation, I mean, which sort of is obvious, it doesn't really give you the answer, does it, to the question of whether it's a fact or an opinion? So he could explain it by saying the fellow had arrived on a horse.
Yes.
I want to give you some background. He arrived on a horse. He got off his horse. I mean, a lot of facts. And then he could say at the end of it, I think he's stupid.
Yes.
And all the stuff about the horse would be a fact, and I think he's stupid would be obviously an opinion.
Yes. My Lord, I accept it's not determinative, and in the example my Lord posits, it doesn't work. But in the context of this exchange and this programme, we say a viewer would understand that largely, if not all of this, was really comment because, in part, because it was explanation. But I don't need to go that far.
That's the point I'm really been putting to you. And
yes.
I won't do it again because it's a waste of time. But a lot of this is obviously fact.
Well,
I know the words disruptive you point out in the first sentence is not,
yes.
but a lot of it is obviously fact.
Well,
it is Mr Corbyn's description to explain to explain the question he's been asked. In other words, why did you say this? And the allegation that's being made against him is some facts. And he was speaking in his defence, and Manuel was the Palestinian ambassador. All that, and we only get to what is said to be opinion, arguably in the first sentence, but later with the very, very abusive bit.
My Lord, yes, and we accepted before Mr Justice Saini, for example, to say that Mr Millett was present at the meeting.
It's a fact.
It's a statement of fact.
Yeah,
I accept that. But
also, it's not defamatory, of course.
As my lady the President pointed out, that doesn't really bother us. We're quite happy with that.
Yeah.
What's at issue between the parties, and before Mr Justice Saini, is, as my Lord Master Arose points out, it's the epithets incredibly disruptive. Police wanted to throw them out. I didn't. Disruptive at a number of meetings. They came up. They were really, really strong on him. He was quite upset by it. Very, very abusive.
I suppose what you're saying, I mean, I'm just trying to sort of to encapsulate it for my own understanding, Mr. Hudson. What you're really saying is that because he's giving an explanation as to when challenged in a very direct way, it is obvious, you say, that when he says they were very, very abusive, that is his explanation, his opinion as to what was happening and why he spoke in the way he did.
Well, precisely.
So that's really what you say.
Precisely.
Any fair reading of it is like that, rather than a factual opinion saying, rather than a factual statement saying they were very, very abusive, by which I mean they swore a lot.
Yes.
Yeah, okay, but I think I get it anyway.
Well, my Lord, that is, if I may say so, my point.
Yeah.
But I'm not sure I can do any better than that, really.
Well, it's very helpful.
So, my Lord, those are we referred before, Mr Justice Saini, and we've referred to it in this in our skeleton argument, the decision of this court in Tinkler and Ferguson, which I know my lady the President was in, and the use of the word disruptive in that case and verifiability. It's not directly analogous because the behaviour was different, but we do say it lends some support to our argument that a reasonable viewer just simply wouldn't understand the word disruptive to be a statement of fact. Partly because it raises issues of verifiability, but also because, as my lord, the Master of the Rolls says, it's just the way it would be understood as an expression of opinion about somebody's behaviour, rather than a clear statement of fact about what they did and how they behaved. But, my lords, my lady, those are my submissions on our first ground. And so, unless I can assist the court any further on that, I'll move on to our second ground, which is defamatory of common law. And I think I've made it clear. I did make it clear that if the court agrees or finds that Mr Justice Saini was wrong on the first issue, we invite this court to consider the matter afresh. I don't need to make any additional submissions on why we say if the court does consider the matter afresh, we say the decision under determination under section 3.2 should be that the statement complained of was a statement of opinion, whilst recognising not all of it was a statement of opinion. So I can develop that further if the court would like me to, either at this stage or in reply, or at another point. But it seems like that the submissions as to why Mr Justice Saini was, we say, plainly wrong, my final submissions, are essentially my submissions that I would make to this court if the matter was considered afresh, as to why the statement complained of was a statement of opinion, albeit not every part of the statement. Well, I'll then turn, if I may, to the second ground, whether defamatory at common law. This is obviously a separate and distinct issue. In summary, we submit that the learned judge erred in five, I'm afraid, five, seems remarkable considering how short the judgment was, but five significant respects. And they all involved errors of law and or fact, and therefore this court should consider the matter fresh. The five errors we rely on are summarised at paragraph 59 of our skeleton argument, page 16. And in any event, we say, and as part of that, we say the judge was plainly wrong to find, and his decision was outside the range of reasonably available alternatives, to find that the statement complained of, in the meaning that he found, clearly met the seriousness threshold, which it must meet in order to be defamatory, and also failed to meet the consensus requirement, which it had to meet in order to be defamatory. We contend if we are right on any of those five, and I particularly emphasise the first sub-ground that I rely on, namely the judge's misplaced reliance on the suggestion, he says, the suggestion of criminal misconduct. We say that vitiates his decision, and therefore, even on that basis alone, it would be appropriate for this court to decide the learned judge was wrong, and therefore that this court should consider the matter afresh. Well, Lords, my lady, the relevant law on determination of whether or not a national order meaning of words is defamatory of common law, we set out in some detail at paragraph 52 onwards, but I'm obviously aware that this court is extremely familiar with these principles, and I think most, if not all, the judgments I rely on were given by members of this court. So I won't labour that point, particularly not at 10 to 1. But I do obviously emphasise two particular principles, which we say that the learned judge simply did not give sufficient weight to, which is reflected in his judgment. Firstly, the seriousness threshold, and secondly, the consensus requirement. And those are summarised. I don't think I need to take the court to these, but those are summarised in the decision of Mr Justice Tugendhat in Thornton, which is at tab 4 at paragraph 96. Namely, the statement complained of must substantially affect in an adverse manner the attitude of other people towards the claimant or has a tendency to do so. And then we also rely on my Lord Justice Warby's judgment in Monroe and Hopkins, which the learned judge says he placed particular reliance on. That's at tab 11. And we rely on paragraphs, in particular paragraphs 50 to 51 of that judgment, which we would invite the court to read in detail. But we particularly emphasise the following point, where my Lord Justice Warby said the demands of pluralism in a democratic society make it important to allow for differing views to be expressed without paying damages for defamation. Hence, a statement is not defamatory if it would only tend to have an adverse effect on the attitudes of the claimant to the claimant of a certain section of society, and that is, we understand to be what is described as the consensus requirement. And we say the learned judge simply didn't give proper effect to that principle when deciding this issue. So, turning to the 5 significant errors, the first one, and we say this is the critical one, the judge found at 99 it's dealt with at 99 to 100 of the judge's judgment. At 99, the judge asked himself, I have to ask whether the type of conduct attributed to Mr Corbyn, by Mr Corbyn to Mr Millett, would be contrary to the common or shared values of our society and modern community. So that's the test the judge was asking himself. And then at 100, his answer was, in my judgment, it is clear that this test is met. Mr Millett was being accused of abusive behaviour in relation to a public speaker on a controversial topic. This is an accusation of a type of conduct which is contrary to the values of modern democracy. Further, the behaviour of which he was accused was of such a level of seriousness at the first meeting to which Mr Corbyn made reference as to involve the police in potentially ejecting Mr Millett and other individuals suggesting criminal misconduct. And my lords, my lady, we submit that reliance by the learned judge on the suggestion of criminal misconduct was central and probably determinative, it seems to us, from the judgment of his decision, that the meaning he found was defamatory at common law of Mr Millett. And as the court will be aware from our skeleton argument, we say that that was a fundamental error to find that there was a suggestion of criminal misconduct. And the reason for that is because there is no suggestion of criminal misconduct, not only in the statement complained of, but more importantly for these purposes, in the meaning found by the learned judge. And the court will recall the meaning is set out at paragraph 80 of the judgment, page 79.
No one was suggesting, this is the point you make, I think, that no one was suggesting that the words implied that there had been criminality.
No.
The meaning complained of didn't incorporate any implication about criminality, any level of suspicions.
My lord, no. There was no suggestion of that.
So, did this come all out of the blue, this reference to criminality?
Yes, my lord. And my lord won't be surprised at that, because to say that the police wanted to remove someone from that someone had behaved in a disruptive way at a meeting in the House of Commons and the police wished to remove them from the premises does not in any way suggest criminal misconduct.
I was just wondering what the function of the police is then.
Well, as my lord, obviously the police have a variety of functions, a variety of roles, which they will exercise in very different circumstances. But the police can undoubtedly perform a role and intervene in situations, even where someone is not behaving in a criminal or unlawful way.
So what do the words actually say? Police wanted to throw them out of the meeting.
Yes.
This wasn't a sort of quiet word, was it? You might think about behaving better. I mean, it was suggesting positive action on the part of the police.
It was, and
which, in the context, would be unlikely to be met with favour by the people they were applying it to. In other words, it would be coercive.
Well,
throwing out is not an invitation to leave.
my lady, I accept that, and one has to understand that in the context in which Mr Corbyn was speaking, but also one has to understand it in the context of what Mr Corbyn says, which is the police wanted to throw them out of the meeting. He said that they'd been incredibly destructive. Indeed, the police wanted to throw them out of the meeting. I didn't. I said they should remain in the meeting. So one's left with Mr Corbyn's statement that the police want to throw them out, but that he clearly did not think their behaviour warranted them being required to leave the meeting. The judge formed the conclusion that the police wished to remove him from the premises. So the judge took a slightly different view as to what those words actually meant in context. But on either basis, we say it does not suggest criminality, and had it suggested criminality, then that is a meaning which ought to have been not only advanced by the claimant, but more importantly, then determined, found by the judge that it carried a meaning of criminality. And as the court is aware, had it meant a form of criminality, that is a much more serious meaning, with implications not only for whether or not it had a defamatory tendency at common law, but also for the basis on which and the way in which the allegation could be defended. So I of course accept the point that to say the police are involved and want to remove someone from a meeting raises questions about that person's behaviour. But one does have to look carefully at what the judge decided. But I don't accept that it necessarily means that someone has behaved in a criminal matter, in a criminal way, because there are demonstrations, protests, disruptions of meetings all the time. As the court is aware, it's very much a feature of modern life. When we were arguing this before Mr Justice Saini last summer, there were global protests which we refer to in submissions. The court will be aware at the moment there are very significant protests about important issues which the police intervene in and detain people, sometimes restrain or even handcuff people. But whether that is suggestive that someone's committed a criminal offence, but more importantly, whether that leads to the defamatory tendency, we say no, because it entirely depends on the context in which it took place, what else is being said about the person, as to what the viewer would get from it. It's obviously at one extreme to say, I won't say Mr Millett, a person had, I used my example earlier, punched the speaker on the nose and the police had arrested him and taken out. Obviously, it's a serious allegation of criminal misconduct, of assault. To say someone was disrupted at a meeting because they wouldn't stop clapping and the police decided to remove them is a completely different allegation, and one which we wouldn't necessarily accept carries even a defamatory tendency.
Well, I'm sure I'm opening a Pandora's box here, but on what basis can the police throw people out of meetings? I mean, surely it's because of some threatening or inappropriate conduct, at least bordering on the criminal.
Public order offence.
Public order, yeah.
My lord, my lady,
It would be the threatened breach of the peace, I presume.
of course it could be, and one might say strictly that's the only basis on which the police could exercise their power.
Police don't have a power above and beyond that which arises from their...
But, my lady, I suppose I've got two responses to that, which is, A, we have to look at the words complained of and the meaning as found by the judge. And the judge did not find in his meaning any suggestion of criminality, any suggestion that the comment by Mr Corbyn that the police wanted to throw Mr Millett out meant that Mr Millett had behaved in a criminal way, i.e. even breached public order or was a threat to public order or something like that. That is not the meaning the learned judge found. And that we say that is the important starting point. But secondly, a reasonable viewer would appreciate that sometimes police or security can seek to remove people from meetings or situations, even if they're not strictly committing a criminal offence.
Yes, well, there must be a range of types of statements you can make about the police taking action. At one extreme, say, you suggest that they were clearly right because there was some criminal conduct going on. At the other end of the scale, it might be suggested that they were clearly wrong because there wasn't any criminal conduct going on. So the mere fact that you've mentioned the police and some wish of theirs to take some action doesn't lead inescapably to the conclusion that there was criminality. But can I ask this question? This is deed construction again, I fear, but in the last but one line of paragraph 100, we've got the words that you're relying on here, which are in brackets, suggesting criminal misconduct. And my question is this: who or what in that passage, in that phrase, is or was suggesting criminal misconduct? Is it the words? Is it the police? Is it something or someone else? What does it mean?
Well, I tell you what, Mr. Hudson, I'm going to relieve you by saying that it's 1 minute past 1, and you can have 59 minutes to consider your response to my Lord's searching question, and we'll resume at 2 o'clock.
I'm immensely grateful.
Very good. Thank you.
All right.